a decision will be that decision will be whether to fund that application will be communicated to them on the 6th of August. And that's why we're here today, my lord, just to hear the outcome of that Committee of Legal Aid South Africa.
Yes, Mr. Minister.
As it is the court, my lord, I'm not so sure if I've got a standing to speak on behalf of the CSC, that committee that made that determination, but we've got a representative from Legal Aid South Africa, Ms. Flavia, yes. So, but there's a communication that has been said to us. I yet have to convey what was said to us to Mr. Mncube and Mr. Sibia and hear their views in that regard. I haven't as yet done that, my lord. Thank you.
As the court pleases, I also confirm that we have received communication regarding our request, and I'm yet to consult Mr. Ndanzi regarding the outcome thereof.
Yes, sir.
My lord, I also confirm that I did receive a communication from the Legal Aid Board yesterday in the afternoon. There's a letter that I received. I still have to communicate the contents of that letter with my client.
As the court pleases, my lord, I confirm that we have considered the issue of bringing Section 175, my lord, and Mr. Ntuli will not be bringing any application for 175, my lord. We'll proceed with the 174. We'll proceed with the defense case, my lord. Thank you.
Is that in respect of your client?
In respect of Mr. Ntuli, my lord, yes.
Yeah. Yes. Okay. So in respect of the other so-called accused, what is happening?
I would request, my lord, a very brief indulgence just to convey the issue that we got from, the communication that we got from the committee that made a determination on this issue to our clients.
So what should we do? Should we adjourn or what?
Yes, just a very brief adjournment. We'll let a court, probably 30 minutes, as is suggested by my colleague. Man.
Okay, yeah, before we do that, I see, did you receive this notice? Rule what? Rule 49(1)(c), Mr. Baloi.
No, we haven't.
Just have a look at it, because it appears like it was served. It is okay. It alleges. No, just read it, all of you. Each one of you must read it and tell me what it says.
As it is the court, my lord, yes, I think we received, it's a notice of
So
motion.
what's your view about
yes. This is the procedure, my lord, that we indicated from the beginning when the court was was assailed
Yeah.
by members from the correctional services, that the procedure that they followed then was very irregular. And what they've done here, it's a procedure that it was expected of them to have been done, my lord. Thank you, my lord.
Mr. Ramsipil.
Indeed, so my lord will call, one of my arguments was that at the time the correctional officers came here and wanted to approach the judging chambers, the chiefing chambers, I said, once a court order has been made, a party that is aggrieved cannot now approach the presiding officer in chambers, because the presiding officer is flutus officio. All they need to do, my lord, is to either review or appeal that decision, which I see now they've taken that recourse, my lord. There's a court cases.
Yes, Mr. Ngomane.
Thank you, Madam. When reading this notice, it is a procedure, as my colleague advocated. It is a procedure, as my colleague advocated in this. I agree with his sentiments.
So they're citing even the minister. Is that the procedure?
No, not the minister.
They're citing the minister and who?
The National Commissioner and the head of the Koshimankuru Correctional Center and the head of local maximum prison. So these are the applicants, my lord. They are not being cited. These are the applicants. So the minister, the commissioner, the head of CMEX and the head of local are applicants, my lord. These are the parties that feel aggrieved by the court order that was made by his lordship, my lord.
Yeah, but they're citing the minister. What's your view about the minister? How is he party to this process?
I think why not on the basis that he is the head of the correctional services, having an interest in the matter. That's my view.
Yeah, okay. What does Rule 49 state?
Well, looking at the document, my lord, I think it's basically just a notice of intention to appeal the order that was made by the court, and they're requesting reasons. So I suppose it's Rule 49 of the Uniform Rules of Court.
What does it say, Rule 49.1?
I think basically it says, before proceeding with application for leave to appeal, that reasons should be sought for the order that was made by the court. And I think that is the purpose of...
Okay.
Yes.
And what happens, because as I understand, the representatives of the correctional services were in court when that order was made. They even proffered some submissions. Now they say they want reasons.
Written reasons, I think that's basically what they seek to achieve, my lord.
Who is the state attorney?
Is it the one mentioned in the documents, or just generally?
No. The one mentioned in the documents.
We have that Rule 49C of the Uniform Court Rules. It says, when in giving an order, the court declares that the reasons for the order will be furnished to any of the parties on application. Such application shall be delivered within 10 days after the date of the order. Yeah, so in essence, they're just seeking the reasons for the order.
Can you phone the state attorney? He must come here because I don't understand what he wants to say. So adjourn for how long? 30 minutes.
I think we can adjourn for as long as we would still be waiting for the arrival of the state attorney, my lord.
He won't come here.
So that when we
Did he
start...
say he's coming?
The state attorney? No, I had a court saying that the state must call the state attorney.
Yeah. So that he must come and explain to us.
Yes.
If his clients didn't tell him the reasons.
Yes.
Because the first thing an attorney, when he gets instructions, the client tells him, this is what happened. And these gentlemen were here in court. And they still want the reasons. Maybe we should give them the copy of the transcript.
Yes, it please the court, my lord. Thank you.
Okay, 30 minutes then.
from the two gentlemen that I'm representing here. But legal aid then says, now, Mr. Mnisi, if you want to proceed with the 174 application, we don't bar you, we don't stop you from proceeding, but know that in terms of us financing it, we'll have some reservations, which is then the communication between legal aid and us then stopped there up until today. Today, they availed themselves to court. On adjournment, I communicated that position to the client, to Mr. Mube and Mr. Sibia, who still are of the opinion that it will be in the best interest of administration of justice from their point of view that we bring this section 174, and then thereafter they started to ask certain questions that I was not in a position to respond to. And then I requested legal aid to go and attend to those questions, or to answer those questions as are questions that should really be answered by legal aid. So there were still some deliberations around the questions that they had been asking legal aid. Then there was a moment when we were requested to come and see the court in chambers with a team from the state attorney. So we had not yet finalized those discussions. But I stated to them very clear that it will be it will be a challenge on my part to go and sit for 4 weeks in preparation of the section 174 without any reimbursement. And I'm repeating that it's going to be a very serious challenge, Manuel.
Without what?
Without reimbursement. In other words, I'd need to go and sit in my chambers for 4 weeks preparing for this 174, because it's going to be a very detailed 174. And at the end of it, will just be seated there, fully concentrating on this application, not be involved in other work. I don't think I'll be in a position to do that, my lord. I've already done that since January. I've read almost like 40,000 pages, and I don't want to get there. But I don't think I'll be in a position to do that for the second time again, my lord. Thank you. That is the position.
But what are your instructions from your clients?
My instructions from the client are that, my lord, they would still wish us to bring the section 174. But the challenge is, who's going to finance it? Thank you, my lord.
Mr. Ramsipi?
If it may please the court, my lord. My lord, indeed, we have had discussions with our instructing attorneys, legal aid, and in particular, Mr. Ntanzi, Sibia, and others, my lord. My lord, briefly, I'm not going to talk about finances and all of that, because that's matters that should be in the private sphere. So I'm not going to talk about that, my lord. My lord, my instructions simply were still to proceed with the application for Section 174. However, having discussed the matter with our instructing attorneys, they feel that we stand less chance in succeeding in the merits thereof. That's what they've just told our clients, that we don't have a leg to stand on the 174 application, my lord. Then I'll have to take instructions again from Mr. Ntanzi, having been advised that we don't stand a leg on the 174. Yet we are given the green light to go, but the view is that there's no leg to stand on, my lord. So I'll have to take instructions, then I'll give the court my final view.
Does your client want to launch?
He does, my lord. That's his instructions to me.
Okay, Mr. Numalo?
My lord, the Constitutional Case Management Committee from the Legal Aid Board said yesterday, and I received a response, as I indicated earlier on, that my request was declined. But I wish to bring to the attention of the court that this issue of Section 174 application It's something that we have been discussing with my client. It's not something that we took overnight. There were instructions all along the trial that I should bring such an application, of which I'm prepared to do so. And I was going to request the court to grant me indulgence. I'd already started to draft the application. If I may be granted a week from today. I was calculating the dates, my lord, if we can be granted up until the 18th of August, 2025 for that application.
Okay, fine.
Thank you.
Mr. Mshololo, you are saying you are not bringing an application.
Yes, my lord, we are not bringing the application for 174, my lord. We will be proceeding with it to first case.
Is there any representative from the legal aid board here in court?
Yes, my lord, I'm the head of office for the Procedural Updates.
So when you assumed the mandate to fund the accused, was it to fund them through the legal process, or did you have conditions?
My lord, no, we did undertake to fund them through the whole process.
Yes.
We did. But the question that came before the Constitutional Case Management Committee was whether they would fund a 4-week preparation for a 174 application. And it was put before them, and a decision was made that they won't fund it. We won't stop them from doing a 174 because that is part of the Criminal Procedure Act. But the Constitutional Committee said that they are of the view that to pay an additional 4 weeks to prepare for a 174, they weren't amenable to that.
Yeah, okay. But you are prepared to fund an application for 174?
Well, it's the appearances,
Yes.
and in terms of the tariff, they obviously are entitled to fees in terms of the tariff. In terms of the tariff, they've got 2 hours preparation per day, plus obviously the court appearance. But in addition to that, legal aids are prepared to give the additional amount.
So you are prepared to fund it for how many? 2?
Well, it's in terms of the tariff.
I mean the tariff
it's
for preparation.
2 hours in trial preparation per trial day, plus the trial day fee.
So it's 2 days.
Well, it's actually 2 hours for the
2 hours, sorry.
preparation, and then
So I hear you. Mr. Nisi, why would you say you have to prepare, and I'm not saying you can't, you have to prepare for 4 weeks. You say it's 4 weeks.
That was just my estimation, my lord. I've taken into account the issues that I need to deal with. I've taken into account the volume of work that I need to go through in preparation for this application, and I've taken into account the number of accused that I'm representing, my lord. And I'm also taking into account the nature of the evidence that was led against accused number 1 and against number 2 up to this stage of the trial.
But you've heard the legal aid board saying the most they can provide is for 4 hours, apparently.
My lord, in the response by the legal aid, they are mentioning that, but they are saying there's a 2-hour preparation that they would pay when the court is sitting, which is a trial date. In other words, for instance, today, they will be prepared to pay that 2 hours which is meant for the preparation in view of the matter that will be proceeding. But now this is different because this preparation will be done when the court is not sitting. So now I requested some clarification from them as to what do they mean by that. I'm unable to get a precise answer on whether or not they are saying it is fine, you can go and prepare, but we will pay you for your preparations per day only for 2 hours, irrespective of whether you're preparing for 7 hours per day, and up to a certain maximum number of days. I don't know what it is that they are actually saying, my lord. I wrote and requested a clarification from them, but I still cannot get what is it that they are saying. Thank you, my lord.
Come and explain again, ma'am. What you...
Sorry, my lord. Yes, what the committee said is that they are only allowed to charge the tariff fee, and they're not going to get paid to prepare for 4 weeks at home. So they're not going to, and effectively that's what they said, and even in the clarity, that's what they said. And they did ask me before court, and that's what I explained, that they will get the tariff, which is 2 hours in trial pre-trial preparation plus the trial. And they also get increased fees per trial date. So they don't get the tariff, they've got special fees for the trial day. And the committee was of the opinion that that's sufficient.
Okay, thanks. Mr. Mnisi, so you say you need 4 weeks to prepare.
I said, my lord, that was just an estimate.
So how long do you think you need, according to you?
I think the court will remember that as early as January, in February, I said to the court, I would have completed reading the record on a specific date. Came that date, I had to come before court again and make a request for a further postponement, and I was lambasted, my lord. So I don't want to go through that experience again in preparation for this. But still, without clear terms in regard to payment, my lord, I would not be preparing. I cannot be preparing anything, because it doesn't really come out clear. But from what I understand from Legal Aid South Africa is that for this section 174, their decision is they are not prepared to reimburse a person that is going to prepare to bring this application on behalf of the accused.
But I thought you had read the record again.
Yes.
You were in court when this matter commenced.
Yes.
Then after that you were granted 4 weeks, 4 months. 4 months and 3 weeks.
And that was after I was lambasted, yes, ma'am.
Yeah, reading.
Yes.
So you still want to read the same record which you have read and you have listened to in court?
It's different now, my lord. It's different.
What is different?
It's different because I'll have to bring an application in terms of 174.
Yeah, so what's the problem?
Then I'll have to revisit the record, my lord, and identify those points that I would want to include in my 174.
So you don't want to represent your clients, in other words?
Excuse me, my lord?
You are saying you are no longer wanting to represent your clients unless and until the Legal Aid Board says they will pay you for 4 weeks, whatever.
No, I never said that, my lord.
What are you
That is
saying?
the problem. That is the problem. I think I am being misinterpreted here. You see. And that has always been the perception that has been in the mind of Legal Aid South Africa, that I am after money. I am not after money, my lord. I was only requesting for assistance, but they are saying they are not in a position to assist. And that request does not come from me. It comes from accused. And if the court says, therefore, I'm saying I'm no longer representing accused, well, that does not come from me. But if that is what the court have in mind, then we can take it from there, and then from there, then we'll have to find a middle ground. And I do not want, my lord, and I'm requesting with due respect that this trial should not be about me. I should not be the centerpiece of this trial. I have been requested to come and assist these accused here, and I think up to thus far, I've done the best that I can. But for the focus of this trial to change from this accused person to be on me, I think that is very unfair. But if there's a perception that has been created that I am therefore saying that I no longer intend to represent this accused person, then let those who are entertaining that perception have it and tell me straight that I am no longer fit to represent these accused persons. Thank you, my lord.
So what are your client's instructions, in any case, about the application?
My lord, I've said it many a times.
Yeah, I just want to hear it again.
They are saying, they are requesting that you should bring this 174 application.
Mr. Ramsipil, you said you were ready. You are ready to bring that application.
My lord, I said it is my intention and my instruction to bring that application.
What's stopping you?
My lord, the same thing that was stopping Mr. Mnisi. Now we have heard that we are covered for 2 hours per day for preparation. I'm amenable to that, my lord. And in fact, my lord, before we even started, I've already started drafting my application for 174. I've already told accused number Mr. Ntanzi such, my lord. I'd already started drafting, my lord.
And Mr. Nomalo, you're saying you just need a week.
Yes, I think there must be clarity, my lord. What this entails is that when the court is not sitting, legal aid is not paying. So this in trial is when the court, like today, in trial preparation 2 hours, then there is payment. Then there is payment for court appearances. So when the issue with my colleague is that when the matter is postponed, say for a week or 2 weeks, then there is no payment at all. But I'm saying on top of that, with or without any payment, I'm prepared to proceed to bring an application on the 18th of August 2025.
And you just need a week to prepare?
Yes, a week.
Mr. Mnisi, are you saying a week to prepare won't be sufficient for you?
Well, my lord, if I come here and present a document that is not up to standard, I would request that I should not be denigrated because of lack of proper preparation.
So 7 days is enough?
I am saying, my lords, in an event that I come here and present a document that is not up to standard because of lack of preparation, then that should not then come and haunt me and say, I have misrepresented the interest of these accused persons because of a shoddy work that I would have presented. Because 1 week for me in terms of preparation will not do, my lord.
Yes, Mr. Baloyi, let's hear you.
As a court, please, my lord, before Advocate Ngumalo spoke, I was just asking myself as to why can the court days be used for preparations, but then he said if the court is not sitting, then legal aid South Africa is not paying. Because if they were paying, then those days could be utilized for preparation. But it sounds like it's just about tariffs, and I don't know if there's further consultation between Council and Legal Aid South Africa. Perhaps a middle course can be found, and we suggest that maybe the parties try and fund each other, and maybe we can already at this stage take the long adjournment and come back at 2 and see if the parties cannot really fund each other.
So it's about money. Mr. Minister,
Sounds
it's about
like
money.
it's about the tariffs. Perhaps legal aid might be prepared to, if the preparations take place during the normal court hours, maybe they might consider paying for the preparation.
Doesn't change their stance, because as I understand, it's a fixed tariff which they have agreed upon as the committee.
Yes. Yes, but I think the biggest problem that they have is to fund a 4-week preparation. But perhaps if maybe the period is shorter and there's a discussion about utilizing court hours, perhaps the parties might find each other.
My Lord, perhaps, dare I say, this has been a very long-running matter. And as counsel or an attorney, when you are preparing and listening to a case whilst it's proceeding, you highlight what you perceive to be the factors that you will include or that will fortify your application later at the end of the state's case for an application for discharge. But because this has been a long-running matter, yes, for myself, and I'll speak for myself, I have identified issues that I say this will assist my client in his application for a discharge in terms of Section 174. Yet now, I need to go and identify that evidence in the transcripts themselves. I'm not going to read the whole transcripts. I'm identifying an issue so that when I say, Madala said this, I can tell the court and say, here's the contradiction that lies there, according to the transcript. So that's exactly what we are perhaps not finding each other for. This is not a shoplifting case of 2 witnesses in a district case, magistrate's court matter, where the state finalizes 2 witnesses, then you apply for 174 because somebody stole a perfume or whatever at the store. But this is a serious matter where you need to identify crisply the issues that you want to raise. And as Mr. Mnisi says, you don't want to bring a half-baked case to court, my lord. So perhaps that's the issue. The issue is not finances per se. The issue is preparation time. That you are told X, Y, Z, but that's for me the clarification. I know the issues that I've identified for this particular application.
So what should we do?
Well, my lord, I think the parties should be allowed to explore further alternatives, and maybe they should engage further and see if they cannot find common ground.
As it is the court, my lord. My lord, I think the court in the level of generality will understand that I'm a creature of instructions. I must take instructions from legal aid directly, basically to a lesser extent from my client, from accused number 1 and accused number 3, insofar as this case is concerned. But insofar as issues such as these ones, it is legal aid who must instruct me what to do. If the clients are saying we want this, it is legal aid that must talk to the clients and say, no, but that's not possible, or that is possible because of this and this and this and this and this. It is not me to come and stand here to try and convince legal aid that this is possible, because I am only a creature of instructions. If legal aid says to me, Mnisi, do it, I will do it. If legal aid says, Mr. Mnisi, don't do it, I won't do it. It's like I'm a pawn. I'm a pawn. I'm a horse. I'm sent here. I mustn't ask why. I'm sent there. I mustn't ask why. But I'm not saying I must do those. Like I must do things blindly. There are certain things that I need to clarify. But insofar as this process is concerned, I think it's a discussion that must take place between legal aid and the client. And after having finalized whatever that they would have discussed, then legal aid comes to me and say, Mr. Mnisi, these are the instructions that you are taking from us. But over and above that, legal aid is not only an attorney, it's also a funder of this whole process. So it's not fair for me to try and appear as if I'm fighting this battle on behalf of Mr. Ncube and Mr. Sibiya. There are no battles that are supposed to be fought here, my lord. It's a question of procedure and systems. I should actually be standing there and folding my arms and waiting for legal aid to come and say, me, Mr. Mnisi, these are your instructions that you're giving me. But it has not happened here. Actually, I should be saving myself from this agony of trying to analyze and convince that this should happen, that should not be happening. I must only be on the part of arguing legal matters here, not these administrative things, my lord. I'm not an administrator, I'm a legal person. That's my duty here at court. But it does not seem to be like that in this instance.
Sorry.
So I would request, my lord, that a further discussion that is going to involve accused number 1 and accused number 3, I should not be part thereof. I'm going to fold my arms and stand there and wait for specific instructions from legal aid, who are my instructing attorney. Thank you, my lord.
But did they pay you for preparation, for reading the record the last time? 4 months and 3 weeks.
I would rather not get there, my lord, because that's also a very sad story. But I would rather not get there. Thank you.
What's your time there, Mr.?
It's 12:22, my lord.
What time should we come back?
We suggest at 2.
2, okay. Adjourn until 2.
My lord, my position ante still stands. The accused are saying, well, they would have wished to bring this section 174, but if circumstances do not permit, they will not bring it. That's their message.
They have agreed what?
They are saying they would have wished for the 174 application to be brought for them, but if circumstances do not permit, then they will go with what is not permitting. In other words, they will go with those circumstances that do not permit them to bring the 174. Otherwise, it can also be confirmed with them, my lord.
Yes.
As the court pleases, my lord, indeed so, I have also reconfirmed with Mr. Ntanzi. It is still his wish that he would like to bring the application in terms of 174, and I must do so on his behalf. With regard to the other issue, my lord, that I don't want us to ventilate it here. The stance from our instructing attorneys is that they don't see the prospects for that. But my lord, my solution will be, we'll go through back and forth. Let it be the conscience of each attorney or advocate counsel to decide, given the instructions, what they want to do. So my suggestion will be the 18th as muted by Advocate Ngumalo should be the tentative date. Whoever wants to apply and finish the written heads will be that date tentatively, and after they've been finished, then the state will be afforded some time to respond thereto, my lord. So we avoid this back and forth. Whatever still needs to be ironed, if there's anything to be ironed with the instructing attorneys, will be done within that period. But that's how far I will take it, my lord.
Yes, Mr. Ngumalo.
I tend to disagree. If there is a decision that is being made. It must be made now. I've made a decision, my lord. So if one says, let us see on the 18th, I've made a decision, a conscious decision, that I'll proceed on the 18th with my application. But the other issue will be the filing of the heads of arguments. I think that's the issue that we have to discuss with my learned colleague, Advocate Badoy, in terms of the filing and the responses to my heads of arguments, when one can expect them to respond.
Okay. Yes, Mr. Chololo.
My lord, I still stand by my submissions that Mr. Ntuli will not be bringing the application for discharge. Thank you.
Yes, Mr. Valui.
As the court, please, we go along with the suggestion of Advocate Ngumalo that we should perhaps set out a timetable at this point for the filing of the heads. As I understand him, he foresees that he'll be finished with his heads on the 18th of August. And the 18th of August, it's...
Sorry, my lord, can I just say, interject, because we have arranged the dates with Mr. Advocate Ngumalo, my lord, if he can...
Which date was it?
The dates for the filing of his heads.
Yeah.
Yes, my lord,
It's
if
when?
you can just clarify for the record. Thank you, my lord.
Thank you, Advocate. Sorry, my lord, sorry. Yes, thank you, my lord. I'll be ready with the filing of my heads on Friday, the 15th of August, 2025.
15th?
Yes, 15th, next week, Friday.
Okay.
Thank you.
Yes. Yes, Mr.
My lord, once the state has received Advocate Ngumalo's head, we need approximately 3 days to file our heads. If we work on the assumption that we would have received them at least at the latest by the 18th, we will need at least, we'll be left with 4 days. We can then file our heads by the 22nd of August, and we can then agree as to when the matter will be argued.
Yeah, come with the date.
I don't know if Advocate Numala would want to file any responding papers to our heads, but if perhaps we allow 3 more days for any further responding papers from the defense side, we're looking at about maybe the 29th of August for any responding papers. And the matter can then be argued thereafter. We haven't decided on the date on which the matter will be argued, but we suggest that either the matter be argued around the between the 28th and 29th of August, subject to what my colleagues will be saying.
28th, is it okay?
My Lord, as things stands, I won't be filing any replying.
Are you only filing any?
No, we can resume on the 25th of August, 2025.
25th?
Yes, we can argue on that day, on the 25th of August, 2025.
Mr. Mnisi, what's your position?
Yeah, before Mr. Mnisi, we've heard from Mr. Ramsepele that any of the council might also consider filing heads. So I think one must also just make a provision for that, and we think the date of argument as being the 28th will make sufficient provision for everyone who might want to file any heads.
Okay, so well, the court orders then that the heads must be filed on the 15th of August. And the response, if any, should be on the 20th of August.
22nd, my lord.
Or 22nd, okay, yes. Fine. 22nd, and then the argument will be on the 22nd, 28th.
25, my lord.
25, okay. So it's, you file on the 15th of August, the response by the 22nd, and the argument on the 25th.
Yes, my lord.
Okay.
Thank you.
Okay, fine. It's so ordered.
Okuzokwenzeka yilo okulandelayo ukuthi nanjengoba ke abameli sebeshilo ukuthi ngeyi-15 kuyona le nyanga kuzoba ke kwiviki elizayo ngolesihlanu i-15 ke na ke August ila khona ke seshilo advocate uNxumalo ukuthi uzodlulisa ke izethulo zakhe enkantolo noma ke bonaka beshushisi base bonake kuloko azobe ekubhalileke kusona isicelo sakhe uadvocate uNxumalo bazophendula ke bona ngeyi-22 kuyona le nyanga bese kuthi ke ngazo i-25 ila khona ke manje sekuzoziwa ke enkantolo kulokho ke okubhaliwe ke phakathi kwabo abameli nabashushisi ke sekuzokhulunywa ke mayelana noma lokho ukuthi ke ama arguments khona enkantolo ngeyi-25.
Okay, is that okay?
That's it.
Sorry, my lord. I've just got one concern, my lord. If we can also just indicate the time frames as we're indicating that we'll be back on the 25th for the arguments on the application of 174. And then in the event that the application is done on the same day or on the following day, we shall then resume with the defense case.
Yeah, I've got to write a judgment, don't I have to?
Oh, that's the court business.
Okay, fine. The court will adjourn.
All right.